Welcome to the Appeals Court. I'm Justice Meade. With me this morning are Justices Wolohojian and Massing will be your panel. Each side gets 15 minutes. You needn't use all of your time, and we do not entertain rebuttal. With that, I'll call the next case, 20P563, Commonwealth versus MONIZ. Ms. Fowle.
Good morning, Your Honor. Amanda Fowle for the appellant in this case. As Your Honors are aware, the issue in this case, it's essentially a one-issue appeal, and that's whether or not the judge erroneously granted the defendant's motion to withdraw his guilty plea based on what is commonly referred to as the alien warnings that were provided. It's our position, as outlined in the brief provided, that the alien warnings in this particular case were sufficient with regards to the warnings that were given. Essentially, under the 278-29D warnings, there's the warnings that were provided. Again, our position is that they were sufficient. The warnings provided indicated that the defendant at the plea was being advised of his consequences, that the consequences of his plea may include deportation, exclusion from the United States, including citizenship and denial of naturalization. The defendant in...
What is our standard of review?
The standard of review in this case, Your Honor, sorry, I'm totally blanking on that answer right this second.
Oh, there wasn't an evidentiary hearing, right?
There was not an evidentiary hearing in this particular case. No, it was decided.
It's a question of law.
Correct.
And the judge who took the plea is the same judge who then allowed the plea to be vacated.
Correct.
So why? So the statute is very unusual. It actually has quotation marks and it says, "Judge, this is what you're supposed to say." Why can't judges just say what the statute says to say?
That would be an ideal situation. I'm certainly not going to say that shouldn't be taken into consideration. The question is, what happens when they don't? What happens if there's a misread or a misstep or something is left out? And I think that the precedent set by case law has been indicated that that's not necessarily detrimental to the plea. The question is, what is left out? What is the meaning of what is left out? And what are the ramifications of that? The case law has settled that the purpose of the alien warnings is to put the defendant on notice as to the issues. The question is, if the judge decides not to just read what is in quotation marks, does that automatically negate every single plea that enters? I submit that it does not. I submit that under the case law indicated, again, there's clear outlines that as long as the warnings are given with a way that the defendant can, at the time of the plea, can understand, then that would be sufficient. I would suggest the rules of criminal procedure also indicate that the alien warnings by the judge are not meant to replace what I would suggest the rules indicate is the more important aspect of the interaction between the defendant and his attorney, who is actually there to advise him of the consequences and actually guide and counsel and advocate for him with regards to those consequences. In this particular case, we have the alien warnings that were given by the judge, and I would suggest, as outlined in the Commonwealth's brief, that we're talking about essentially the misstatement of, or missing the omission of one, maybe two words at that point. And the question is that sufficient to negate the entire plea? I don't believe so. When we're talking about the words that were omitted, the definitions of those words by the legal standard are virtually the same, realistically, in a common sense aspect of it, and more than the common sense aspect of it under the Black's Law dictionary definition of it. So in the legal definition, they're remarkably similar. Based on that, as well as the fact that the defendant was represented by counsel, he did have the opportunity to speak with his counsel with regards to that plea. I don't think there's sufficient evidence that he wasn't aware of what those warnings were. The key word
I'm sorry. Did the omission of the two words bear directly on the consequence that the defendant then was facing?
It's my argument that it does not. The words that were omitted essentially were that he would be denied admission. He was already present, he was already admitted, he was already living in the United States at that point in time. What he's seeking now is either a form of citizenship or a form of naturalization in order to avoid his pending deportation. So I don't believe, and I think based under the legal definitions, I don't think that the denial of admission with the admission word being omitted, I don't think that bears on his exact consequences that he's facing right now, to wit, deportation.
But it didn't include also naturalization, or am I mistaken about that?
I believe it had just left out admission, but I would defer to my brief for the exact quote.
The judge said citizenship instead of naturalization. It might result in the denial of citizenship. She's supposed to say it might result in the denial of naturalization.
Is that an argument the defendant's making on naturalization?
I don't believe so. With regards to what has been presented by me, I believe that the argument by the defendant is the entirety of the alien warnings, both under the statute as well as under the rules of criminal procedure, the subsection of 12C3A3. And I think based on those rules, and I think that notes within the rules in conjunction with the case law very clearly indicate that the warnings, while certainly preferential to be read, as Justice Massing indicated, to be read by the quotation that's directly laid out for judges to read, failure to do so does not automatically negate the guilty plea.
I note also that not only the judge, but Rule 12 of the Rules of Criminal Procedure misquotes the statute as well.
Correct. And there is indication that the rules as well as the statute, certainly it's essentially two layers of protection with regards to those alien warnings to ensure that those alien warnings are provided adequately. And I think in this case, especially when looking at the issue that the defendant is actually facing, again, to wit, the deportation, he's advised of that. He's advised of those consequences very clearly.
Has this court or the SJC ever said there's any consequence to a Rule 12 mistake?
The indication with regards to the case law on the Rule 12 mistake seemed to, in my review of the case law, seems to indicate that it depends on the severity of the violation of the Rule 12 mistake and if there is also the statutory mistake as well. Certainly, if there's an error with regards to both of those that do not advise the defendant of the exact consequence that he's facing, then it would be automatic.
In Petite Home, the SJC said there's no consequence. There's no stated consequence. Excuse me. Unlike the statute was the stated consequence. So
Correct.
Are you saying there's something after Petite Home that states a consequence?
I'm saying that it doesn't. That it takes it on a case specific issue. I don't think there's a specific outlined consequence that's recited after Petite Home.
I'm just asking if there's a case that says there's a consequence.
I don't believe so, no.
Okay, thank you.
With that argument, unless your honors have further questions, it's a one issue case and I don't want to belabor the point, so I would rest on my brief at that point.
Thank you. Mr. Pomelo.
Yes, good morning, your honors. May it please this honorable court. Attorney Todd Pomelo on behalf of the defendant appellee, ELTON MONIZ. I agree this is a one issue case, and at issue here is what's the remedy when a court fails to give the so-called alien warnings that are required by 278 chapter 29D, section 29D, that have been in effect since the early 1970s. The judge here, who was also the plea judge, harbored doubt, which to me strongly suggests that in using her discretion, she had doubt about this plea. She read the affidavit of the defendant. She read all the legal arguments that were raised by myself and the Commonwealth and harbored doubt about the warning she gave. And that's because the warning she gave is incorrect as a matter of law. She left out completely the concept of admission. Under the Immigration and Nationality.
Mr. Pomelo, is there a case that says the 29D warning must be given verbatim, and if it's not, then a plea has to be vacated.
There's no case that states that exactly, Your Honor. However, the case that the Commonwealth relies on primarily is from the appeals court, the Hasten case, which discusses how the warning should be conformably within the statute. Then you have Hilaire from the SJC from 2002 and numerous other cases that essentially say the preference is that the judges read the quoted language from the statutory from the statute. So what happens here is, for example, a question was raised about the citizenship application. The judge here doesn't say denial of naturalization. She says denial of citizenship. Well, to become a citizen, you apply for naturalization. In that area,
a person who gets naturalized becomes a citizen. Why aren't they synonymous?
They are synonymous, which is why I didn't raise an argument that failure to give a warning.
Well, let's talk about exclusion and inadmissibility then. What's the difference between those? And if immigration law treats them as functional equivalents, how is there a violation?
Because immigration law does not treat them as functional equivalents. Discussed in our motion below, in our reply to the Commonwealth, and in our appellate brief, we cite case law matter of Rodarte from the Board of Immigration Appeals, which is the leading authority on immigration interpretations of the INA. We cite that case to, we also cite Ira Kurzban. Kurzban is the equivalent of Lafave on the Fourth Amendment. He is the preeminent authority in the United States on immigration. He has a source book that is the size of the old phone books, and it is immigration lawyers bring the book to court, the judges cite it, and in there's a whole section cited in our briefs about exclusion from admission to the United States and how the concept of admission encompasses not only denial of reentry, which would occur outside of the United States, but how one is excluded from admission when requesting admission. You request admission in numerous circumstances. For example, Mr. MONIZ, now married to a U.S. citizen, is requesting admission to the United States through an application for what's referred to as a green card, lawful permanent residence. And in doing so, these convictions bar him from ever being admitted to the United States for that purpose. You can be excluded from
since he's here, or maybe he was here. The immediate consequence that he faced was not exclusion from admissibility. And the SJC has said in the Berthold case that it's the consequence that the defendant then faces that matters. And there's no argument that he wasn't adequately warned about deportation. So why is this different from Berthold?
This is different from Berthold because Berthold requires two prongs, that you allege that a warning wasn't given and that you face more than a hypothetical risk. Here he faces more than a hypothetical risk. And one of the errors with the Commonwealth's argument that it raised before the motion judge as well as on appeal is the Commonwealth seems to suggest that the consequence must occur during the plea. It does not. It's prospective in nature. It's not like a Padilla motion where you need to show prejudice occurring at the time of the plea. There's no prejudice requirement here. You have to show that you suffer from more than a hypothetical risk. So while he was in prison for this case, he married his long-term fiance and applied for a green card. That's a request for admission to the United States. However, he's ineligible to get that green card because he currently faced, at the time of this motion hearing, he faced an exclusion from admission to the United States. The judge never warned about admission. And if you look at the alien warning statute, I think it's very clear that the legislature was patterning the warning off of the three main bodies of law that most immigrants face. You can be deported. Deportation is under INA section 237. You can be excluded from admission. Admission is section 212 of the INA. And then others that have green cards can eventually apply to be citizens, and they can be denied naturalization through an application for U.S. citizenship.
What's the difference between exclusion and exclusion from admission?
The distinction as discussed in our brief, I think, is the following, Your Honor. Exclusion would be if you're outside the country and you're entering, you can be excluded from the country. That used to be referred to as denial of reentry. Under the old section of the Immigration and National, before the INA existed, there was people were placed in exclusion proceedings and people were placed in deportation proceedings. And these laws were all rewritten in 1996 and 1997. It's discussed a lot in other cases such as Clark and Commonwealth versus Sylvain. Those are Padilla-based cases, but they discuss the whole area of the reforms of the immigration bills. And you no longer have those types of proceedings. You have removal proceedings. And to be removed from the United States, you're either inadmissible under Section 212 of the INA, or you're deportable under Section 237 of the INA. It's one or the other. It's not. And here he is inadmissible under Section 212.
Maybe I'm missing, but putting aside that before ARERA, the terms were used interchangeably. You keep comparing exclusion from deportation, and my question was, what's the difference, if there is one, between exclusion and exclusion from admissibility?
Well, I think it's a exclusion from admission is one concept, and that's how it's been treated under the law since the
and
at least
how
the
is that
mid-90s.
different? How is that different from exclusion?
Exclusion refers to the old exclusion proceedings that no longer exist under the laws.
What is admission then? What is exclusion from admission? So we've established that exclusion is the denial of reentry. What is exclusion from admission?
It includes, it's a broader concept. It would include being excluded or denied reentry, which would occur once you've exited the United States. So for example, let's say Mr. Moniz left the United States.
Right, but that's the same as well. That's the same. What's different?
Because being excluded from admission can occur within the United States border. For example, Mr. Moniz can go to an interview at the JFK building, in Government Center, and be excluded from admission when he's denied his green card application after being interviewed by the United States Citizenship and Immigration Service. That action of seeking admission to the United States can occur within and without the border.
So it's what you're saying, that exclusion from admission includes denial of, well, admission is legally admitted, whereas exclusion is just physical exclusion. Is it something like that?
I think exclusion refers to being excluded from the United States, which would require you to be outside of the United States and trying to re-enter. Whereas admission can occur.
That's exactly what the judge said, exclusion from the United States.
Right, but he's currently within the United States seeking a request for admission for which he will be denied. He's inadmissible. He can't get his green card.
That goes to the Berthold problem. That is not the consequence that he was facing at the time of the plea.
He does not have to have a consequence at the time of the plea, Your Honor. He has to have a consequence in the future. He currently has that consequence now, and he wasn't warned of it during his plea. And that's the issue. For example, a person might be here with DACA and 30 years later is applying to be a U.S. citizen, and they weren't warned about the consequence of being denied citizenship one day. It's not at the time of the plea. It's not like a Padilla motion where you have to prove prejudice at the time of the plea. You have to prove it at some point in the future you face more than a hypothetical risk. And he currently, at the time this motion was allowed, he faced the risk of being excluded from admission to the United States. Notwithstanding his application for a green card, the government was putting him on a plane in February and deporting him from the United States.
What do you say to the Commonwealth's argument that apart from the crimes that he committed, he was deportable for having overstayed his visa?
That argument about it would be on the prong of being warned about being deported. He's what's called a visa overstay. So under Section 245A of the INA, any person who overstays a visa only suffers that consequence once they leave the United States. So if you leave the United States, you may be barred from reentry for 3 to 10 years, or if you have a criminal conviction of any sort, you may be denied on a separate basis for being inadmissible. So that consequence only goes into effect once you've physically departed from the United States. So here, for example, let's assume Mr. Moniz had no convictions at all and overstayed his visa for 15 or 20 years. Once he applies for a green card through his U.S. citizen wife, he never has to leave the country. He just goes to an interview. And as long as he establishes that it's a good faith marriage and he's not inadmissible to the United States, his request for admission is approved and he's granted lawful permanent residency. So that's how that body of law develops.
Did his marriage occur before or after his conviction?
The marriage occurred after his conviction. He was engaged shortly thereafter. He basically married his high school sweetheart. And when he applied for the green card, the government was still seeking to deport him. They placed him in a bizarre type of removal proceeding where he was essentially automatically deported from the country as an aggravated felon. And he never had the opportunity to go to the immigration court and apply for any type of relief from removal because he was ineligible for any types of relief from removal. And he was ineligible for his green card, which is why this motion was filed. At the time of the judge ruling on this motion, he was permanently inadmissible from the United States, notwithstanding his green card application. and he was never warned about being excluded from admission. Regarding our second argument, the Commonwealth never addresses at all the failure of the court to give the so-called De Jesus warnings, which went into effect through a revision of Rule 212 in 2015 after the SJC's case Commonwealth versus De Jesus. None of those warnings were given at all by the judge, and in footnote 3 of her memorandum of decision, she noted that she need not make a decision regarding the omission of those 3 warnings because she was allowing this motion on the 278-29D basis. So even if this court agrees with the Commonwealth's contention that the alien warning given was sufficient regarding exclusion from admission, which we believe it was erroneous, a remand would nevertheless be required here because the court would have to decide whether prejudice was established. That may require an evidentiary hearing. Those are issues within the sound discretion of the motion judge that she decided she did not address.
Let me ask you the same question that I asked your sister. What is there a case that outlines a consequence for a mistake in the Rule 12 instruction?
No, the way that motion would be decided in Rule 30B is, whether justice may not have been done. And any Rule 30B motion, you can make numerous arguments: violations of ineffective assistance of counsel, due process. Our motion.
So there's no case that says there's a consequence.
Well, there's no case that says there's a required vacature, unlike 29D. 29D requires vacature if a warning was not given and you show that there was more than a hypothetical risk of suffering from that non-warned consequence. Any other Rule 30B motion requires a judge, I think, deciding that some type of legal error occurred during a plea colloquy and that the defendant was prejudiced by failure to receive that particular warning. There's cases where judges don't give warnings about jury trials or other types of warnings. And in any one of those motions, you have to establish a prima facie case of prejudice in order to be successful. And I think really what's at issue here is all the case law says is within the sound discretion of a motion judge, particularly one who handled the plea, and whether to allow a motion for a new trial. And here the judge harbored doubt about her warning, which strongly suggests to me that she credited the defendant's affidavit. There's no suggestion otherwise. And in his affidavit, he alleged that he was confused about this warning. He would not have pleaded guilty had he known this consequence, and the judge ruled in his favor. And that on that basis alone, we would respectfully suggest that this court should affirm the motion judge's decision vacating his plea and ordering a new trial.
Okay, thank you very much. Thank you both.
Thank you, Your Honors. Have a wonderful day.